the first to know. Nsem-Pii TV.
The mighty minority in parliament, heavily represented by New Patriotic Party members of parliament, say after the Ghana there, so be we our punch sixer, no correct 6 ni na no the 4 bar. Because obi we are 6 or the 4 abenti. Attorney General say yenja no yeden nonko. Na nka yanche no alpha 4 amba nka 6 ni na ahwere won nti. Or the 4 nko amba de yeden yenje na yenja no onko. Assemble na aba Dr. Duffuor, the state against Dr. Duffuor case of over 5 billion Ghana cedis causing financial loss to the state. Charges are the board no. State Attorney General Mr. Ayine say yenjano non-co because we timi a retrieve asset worth nearly 800 million Ghana cedis. Now, the voice is so the entire or being say logically sound say charges against Dr. Kwabena Duffuor are up to the tune of over 5 billion Ghana cedis. After the ending, yenjano or filing nolly prosecute after only Dr. Duffuor Kotnase and Omana, even landed properties and your cash impo landed properties at the state after the Motonwa on Betimenia 800 million Ghana cedis. Now, in 2017-2018, and the government of Ghana decided to be a banking sector cleanup because it may be a cost in the banking sector, not anything in 3 years. Liquidity issues, insolvency, weak corporate governance, and weak yisika every banker near buo money de kaka security officers a buo. In Tisaria Bank of Ghana for step in say, one or sa local banks is no or moon share esu yi sika no mo de ye nyema foforo. In Tisaria yenje management na anything every omonza. I no be na Unibank. March 2018, Bank of Ghana decided to take over the management of Unibank, citing says insolvency, inability to meet the financial obligations. Subsequently, in August 2018, and Unibank for a license, a free omonse. And consolidated and no as well as UT, Base Capital, some other banks, 4 banks, and now consolidated Bank of Ghana and now your friend is CBG. Now, almost as we are no file certain charges against shareholders, management of these various banks. They be Base Capital and then Kofobe Breakers from Dr. Duffuor so almost file the same charges against it. But before then, Dr. Duffuor a Ghana Bank of Ghana governor was also a former finance minister of the Republic of Ghana and also a Equatorial Bank. Unibank. Now, charges against Dr. Duffuor the first one, willfully causing financial loss to the state. Allegations say actions of by the directors and the shareholders lead to significant financial losses. Decisions be able to take as directors of the various banks. Ama Ghana, Bank of Ghana, actually sika bebre. And be na calculate here, do 5 billion Ghana cedis. Now, fraudulent breach of trust. Sika omusi omuni. No more chiro wo books mo se omuwo. Sani ya ebe painti picture say omu yeden omuni any form of liquidity challenges. And no be charges are omudeba. And money laundering. Instances of charges related to illicit financial transactions. And also eka charges are the state at the board Dr. Duffuor. Then and a contravention of Ghana Bank of Ghana Act. Bank of Ghana for breaches of banking regulations. The receiver sought to recover a substantial amount, reportedly over 5 billion Ghana cedis, from the defendant, alleging illegal transactions, unlawful loans, and acquisition of assets by related interest. Inti nyema omode masi won mo loans, won mo musika, won mo and may be related to the bank. What you say? In fact, the Bank of Ghana in Bra, or say director central so and fire them and for manage the banking affairs. Now, Dr. Duffuor in turn, then at the case ne PMO Supreme Court said almost challenge the suit against the state against Unibank and our normal directors. Case na ako aba and then you Attorney General say on Dr. Duffuor Kotanasi and on who say Dr. Duffuor say obetima man 800 million Ghana cedis in landed property. Inti sadia we jai case no I am a civil case we jemu say Dr. Duffuor and penny baby anything emfa inti case no the state will not continue it again. And mighty minority led by Honorable Asumedu and various members of parliament in the minority caucus organize a press conference and the floor of parliament, chambers of parliament to say so biaba be we our punching among point washiro punching by 6 now say odi 2 aba o say odi 2 aba intino 4 na by and then cash into NG2 no near the Yemanenko ta ene wo Ghana embremu na sadia omo ye de omo ma the attorney general some few days say once ne direction regarding Ministry of Justice then they will all interpreting the laws of this Republic of Ghana omo de wekwa PM Supreme Court yengo tie mighty minority omo press conference release here as against the statement of the attorney general the learned lawyer Ayini.
The court, I am told that they had called even the second prosecution witness. But today, the learned Attorney General tells us that on his own, he comes out and says that he negotiated with the parties without any court's involvement, and he intends to free. He has already entered a nullity procedure, so he had freed them. The next question, or question 3, that I may want to ask. Transparency, as indicated in the press release, demands the learned Attorney General to explain to Ghanaians the principle of 60-40. Ladies and gentlemen of the press, once a null procedure is entered by the Attorney General or the prosecution, we need not find out, and we don't need to find out questions. But he chooses to, if you read the press release, he chooses to justify why he had done that in the name of transparency. And that's why I say that transparency, as he had indicated in the press release, demands that he, the learned Attorney General, would explain to Ghanaians the principle of 60-40. If you're talking about 5.7 billion cedis and you tell us that you have retrieved 800,000 cedis, how can you say that that represents 60,000? And at any rate, is it a new policy directive, or when did this come into Ghana? When was this introduced into our criminal jurisprudence? What happens to the remaining 40%? To him, the Attorney General, today we heard him say that the 60-40, we can forget about the 40% because he uses the proverbial theft of sage goats, that if 2 or 4 are recovered, then he can allow the 2 to go off, meaning that the 40%, what the Attorney General in his jurisprudence is telling Ghanaians that he would let go the 40%. That means the 40% should go with. The press release makes reference to 60% recovery threshold as a benchmark for reconsidering prosecutions. When was this policy introduced and under what legal authority? Was this benchmark made public or debated in Parliament? Was it quietly introduced post-2024 to lower the standards of accountability? For a case involving 5.7 billion, can the Attorney General confirm that 1 billion has indeed been recovered and provide documented proof of the recovery? It is strange that the Attorney General is insisting that the amount of 800 million cedis recovered from Dr. Duffuor constitute 60%. How did the Attorney General review the amount from the 5.7 0.7 billion to 1.2 billion by a mere administrative fiat. The best we heard from him today is to make arrangements for the amount to be paid into public fund. One would have thought that he would wait until the amount, the recovery that he's talking about, would have been paid into the coffers of the state before thinking of nolle prosequi. Did the Attorney General consider Section 35 of the Caucus Act at 459 in coming out with the 60-40 threshold? For the avoidance of doubt, Section 35 of Act 459 states, and for the lack of time, let me paraphrase, that if you want to make any restitution in such cases, you consider Section 35, which says that a person may plead to a lesser amount, and then you can then enter a nolle prosequi or file anything for the court to consider. And if the person fails to do that, then the person could be punished. When I finish, I can give you a copy of what I'm holding, and then you can have the full text of Section 35 of the Caucus Act. Why did the Attorney General turn a blind eye on the above institutional provision? Why would the Attorney General also look at the principle of the plea bargaining agreement? Under our section, that is the Criminal Procedure Act, Act 30, as amended by Act 1079, and I have a copy of the Plea Bargaining Act as amended. The Attorney General is telling us today that he did not even look at the Plea Bargaining Act. He didn't look at the Caucus Act. He didn't look at the Plea Bargaining Act. The process was not supervised by any court. And what he is telling us is that he himself, on his own, so motu, got the parties and negotiated with them. Where did he get the figures from? When the prosecution had already started this prosecution, and I have the facts as presented by the prosecution, and those who are interested, I can give you copies, you make copies of that. And when we had done this, why did the Attorney General ignore this, and why didn't he tell us anything from this? Why was the accused person not convicted, even when he agreed to pay 60% in line with plea bargain agreement under Section 35, or under the plea bargaining agreement, or under Section 35 of the Caucus Act? For plea bargain to be accepted by the court, there are a lot of options opened to the parties, including conviction. However, any such process must be supervised by the court. In the learned Attorney General's nolle prosequi, he just enters. Nobody would have thought that we would ask him questions. But because he chooses to say that he wants to be transparent, we want him to be more transparent and answer the questions that we are asking him. So how the Attorney General allowed the accused person to walk free without a conviction and without supervision of the process by the court? That definitely cannot be under a plea bargain agreement, as he had himself said. And if it is not a plea bargain agreement, and it also doesn't come under Section 35 of the Caucus Act, where did he get the 60%, and how much has he collected? Today he tells us that he's going to make arrangements for the monies that have been collected, about 800,000, to be paid into government coffers. The learned Attorney General has obviously forgotten the theories of prosecution and punishment. In fact, if he had thought of it, he would have appreciated that deterrence is one of the theories that we take into consideration in punishing people. Ladies and gentlemen, as we conclude, we would like to take this opportunity to call on all voices of conscience in our society, especially lawyers, judges, civil society, clergy, traditional leaders, and you, the press, to sit down and watch, and not to sit down and watch on unconcerned, whilst the Attorney General, trusted with the office responsible to uphold the rule of law, on the contrary, pursue rather a destructive agenda to the detriment of the good people of Ghana. We therefore call upon any interested party, the Parliament of Ghana, particularly its Select Committee on Constitutional and Legal Affairs, to summon the Attorney General to answer these questions publicly. The Legal Council and Bar Association to investigate potential breaches of legal ethics and professional conduct. All patriotic Ghanaians to stand up against what appears to be the erosion of justice and the dangerous politicization of the prosecutorial process. Finally, may this press conference also serve as a formal notice to the Attorney General, Mr. Dominic Ayine, that if his decision is not reversed within a reasonable time, the minority will consider its options of proceeding to court to challenge its decision in its entirety. Let it be known that justice must not only be done, but it must be manifestly seen to be done. Thank you. If there are some questions, I will take it. If you have one of the actions that we heard him this morning speak to the press, and we said twice to answer what he's doing, and we think that he's not doing the right. So once we've come out with this press conference, we have to hold him accountable. You see, he gives an impression that the system that he made is not helping to retrieve monies, and that monies are going to waste. But I will get in the same financial sector crisis, I will cite the case of the Crowell and Associates in Unibank. When the court supervised, the court said that they should pay 1/3, and they paid 90 million cedis upfront before. And when he was not able to pay the rest, the person is convicted and is in jail now. So it's not a matter of saying that I won't put people before jail. There are laws in this country, and deterrence is also right, so that if somebody does the wrong thing, you punish him. We hear the Attorney General also citing the Beige capital issue now as an example, which is a clear indication that he doesn't even plan to take the case further, probably appeal against the decision of the court. It means that he is satisfied. And he also gives an impression that he is not perturbed about financial crimes. And he equates civil actions or civil threshold to criminal threshold. And I think
previously reported exposure of 5.7 billion down to 3.3 billion, which comprise the following: the exclusion of 2.1 billion in the alleged fictitious amounts booked to the account of the shareholder who did not involve cash outflows. In other words, monies didn't go out to anybody. These were just book entries that were designed to make the books of Unibank look good. That is how come that in the criminal case, the charge of falsification of accounts was brought against them. So they did not loot the money. They did not give the money to anybody. They just made entries that were meant to give Bank of Ghana, the central bank, the impression that the bank was doing well. Okay? Then the exclusion of 0.3 billion relating to Unibank's placement with a SEC-regulated, SEC-regulated related company currently in receivership, which is being pursued separately through the insolvency proceedings. After prolonged negotiations, the accused persons, by a letter dated 7th May 2025, made a proposal to settle the revised outstanding obligation of 3.3 billion Ghana cedis through a structured approach. The accused persons offered to pay 2 billion Ghana cedis in full and final settlement of the outstanding obligations through the following arrangements: 800 million worth of assets to be transferred directly to Unibank, which is in receivership, which will now make that available to the Bank of Ghana. And then their active cooperation and participation to assist the receiver to recover an additional 1.2 billion from the direct beneficiaries paid out on their instructions. Out of the above arrangements, the accused persons have provided landed properties valued at 824 million Ghana cedis to Unibank. That is, in receivership. Further, in other words, indirectly to the Bank of Ghana or the Republic of Ghana. Further, the accused persons will be responsible for any shortfall in the proceeds realized from the sale of the landed properties. A total of 0.5 billion has to date been recovered out of the 1.2 billion being pursued from the direct beneficiaries. Recovery of the remaining balance of 0.7 billion out of the 1.2 billion Ghana cedis and the realization of the landed properties provided are expected to be completed over a timeline of 18 months. Although the preference would have been for me and my team for the accused person to settle the proposed amount in cash, immediate settlement in cash was not, from my sense of what transpired at the negotiations, a realistic possibility or a realistic option. In assessing the proposal submitted by the lawyers for the accused persons, I took into account the following factors. The receiver of Unibank acknowledged that the fictitious amounts totaling 2.1 billion did not result from cash outflows, but related to accounting entries that overstated the asset base of the bank.